Hello, my name is Andrew Meikle. I am an intellectual property attorney and a partner at my firm Birch, Stewart, Kolesh & Birch in Falls Church, Virginia, just outside Washington, D.C. in the United States. I have been a member for almost 30 years of Ficpi, the trusted global community which focuses on strengthening the practice of the independent IP attorney. I am the immediate past president of Ficpi's U.S. section. I've presented at and attended many Ficpi-sponsored events, including the ever-popular Fora. Hopefully, you have viewed the video presented by my Ficpi colleague, Jerome Colleen, in which he offers an introduction to substantive patent law harmonization, or the acronym Splh. On behalf of Ficpi, in that video, Jerome makes the case for harmonization of international patent laws based on a balance representing the needs of various users. Ficpi believes the debate about Splh should be broad and transparent. The debate should include representatives of the various users and other stakeholders in the patent system. There are three main aspects to Splh currently under discussion. Two of those topics are grace period and conflicting applications. Colleagues from Ficpi are tackling those two subjects in separate videos. The third main topic under debate is prior user rights, which I address in this video. Prior user rights is a defense to patent infringement that can be established by a third party. It provides evidence of prior use of the patented invention. If successful, it allows the third party to continue use of its invention. Let me share a few more details about how and when prior user rights can be acquired. Prior user rights must be based on commercial use or significant preparations made before the priority date of the other party's patent application. Prior user rights can be acquired even if the third party obtained knowledge of the invention from a pre-filing disclosure by another party. Prior user rights can also be acquired even if the patent owner benefits from the grace period. As I mentioned, we look more deeply at the grace period in another video in the Ficpi Splh series. The risk of prior user rights being acquired by another party is an important factor that encourages an applicant to file early. Now let me expand on the key justifications of why prior user rights is an established tenet of intellectual property law. First, while the overall intent of a patent system is to encourage innovators to protect inventions, the innovator should not be forced to use the patent system. Another option is to protect the invention by use of a trade secret. Secondly, it is fair in commercial enterprise to make investments and pursue innovation, irrespective of subsequent activities by parties who may later file patent applications. Thirdly, in jurisdictions that have an effective grace period, prior user rights encourages innovators to file patent applications early rather than rely on the grace period. Finally, prior user rights allows the prior user to further develop the technology before disclosing it, knowing that prior user rights will provide protection if needed. Next, I want to explain how eligibility, timing, scope of use, and burden of proof factor into prior user rights. Eligibility is granted to the actual person or business unit exploiting the invention. This means the person or the business have made significant financial investments or preparations for exploitation. With regard to timing, the prior user must start commercial exploitation or make significant preparations before the priority date of the patent application. Looking at scope of use, only minor modifications are allowed that are within the essential scope of the invention being exploited by the prior user. Finally, the prior user has the burden of proof to establish prior user rights. Having shared with you the basics of prior user rights, now I will explain the position that Ficpi takes regarding important aspects of the topic and the rationale for our opinions. I mentioned a requirement of acquiring prior user rights is that a prior user began commercial use or significant preparations before the priority date of the application process, even if the patentee relied on grace period and had already disclosed the invention publicly before the priority date. Ficpi believes that, in addition, the prior user should have to satisfy at least one good faith requirement. Examples of good faith requirements are that prior users must demonstrate one of the following. First, they conceived of the invention independent of the patentee. Second, that they exploit the invention based on knowledge in the public domain prior to the time the prior user began commercial use or made significant preparations. Third, that they derived non-public knowledge of the invention from the patentee and started prior use with the direct or implicit consent of the patentee, so long as the prior user had no contractual or implicit obligation to refrain from use of the invention. Ficpi believes these good faith requirements strike a proper balance among the various stakeholders, such as patent applicants, developers of technology, third parties, and the public at large. Regarding territorial issues, Ficpi's position currently is that it is not clear in the regional patent system if prior use is limited to within a specific nation state. Ficpi believes that this can be resolved by requiring that the continued use of the invention by the prior user must be limited to practice within the jurisdiction of the prior use. I'll wrap up this brief overview of prior user rights by underlining Ficpi's belief that a robust patent system should include both prior user rights and grace period provisions that work together so as to encourage early filing of a patent application, allow third parties who early on commercially exploited or significantly invested in a particular innovation to protect that innovation by trade secret or prior user rights, and allow patent applicants the protection of a grace period. Ficpi also endorses the good faith requirement to help strike a balance among the various patent system stakeholders. Thank you for your time and attention to this important topic. If you would like to comment on this topic, please do contact Jerome Colleen at his email address, jerome.colleen@ficpi.org. That's JEROME.COLLIN@ficpi.org. Thank you.